Hello everyone, good evening, welcome to ACE Online. So in this video we are going to discuss some important questions about Indian Polity and related to SSC JE and CGL, RRB, JE, NTPC, any state level examination also. So it is the first video of Indian political system regarding this series, and in this video today particularly I am going to discuss the questions, the terminology which are recently in the news only. So in this video don't expect questions from all the chapters. So in the beginning I am telling that. So in the next video I am going to touch the questions which are related to all the chapters like fundamental rights, data principles, state policies. I am going to touch every subject, every chapter. So I mean the most expected questions from every chapter. But it is the first video. In this video I am going to discuss a few questions, some questions, and which are recently in the news only. So that is what this video confined to, only the terms which are recently news only. Okay, I don't expect the questions from all the chapters. So let's start without wasting time. The first question, which of the following statement true about removal of Supreme Court? So here multiple options are there. Sir, why are you giving multiple options? So just for sake of understanding, just I am asking multiple questions, multiple options. Which of the following statement true about removal of Supreme Court judge? First option, on the grounds of misbehavior, incapacity. Procedure mentioned in Judges of Inquiry Act 1968. Resolution can be introduced in any house. Requires 2/3 majority of the present and voting only. So the full-fledged information about removal of Supreme Court judge. You know why I have framed this question? Because recently there is a news about one Supreme Court judge removal. It is in the Supreme Court. The issue is going on. Yes, now there is a chance to ask a question in upcoming state and state level examination. So what is the answer? So I said multiple options are correct here. Multiple. You can say like ABCD, ABC, BCD like that. Multiple options are right. Okay. So on the grounds of misbehavior and incapacity, it is the right answer. Of course, in detail was not mentioned what exactly misbehavior incapacity in detail, but it can be removed. Of course, this procedure is same for High Court judges, Supreme Court judges. High Court judges, Supreme Court judges can be removed on the grounds of misbehavior, incapacity. It can be misuse of authority and everything like that. Procedure mentioned in Judges Inquiry Act 1968. Yes, it is absolutely right. So in this act, the detailed procedure was mentioned. What are the grounds? What is the exact procedure? The detailed procedure mentioned in this act, right answer. Resolution can be introduced in any house. Yes, it can be introduced in the Lok Sabha. It can be introduced in the Rajya Sabha. It can be introduced in Lok Sabha, Rajya Sabha. Thus resolution, yes. And so first one is right, second one is right, third one is right. Fourth one is actually wrong. Of course, this statement is partial right because requires 2/3 majority of the present and voting only here. This is a wrong statement. So it requires not only 2/3 majority of the presenting and voting place not less than 50% of total membership of the house. Not less than 50% of total strength of the house. So there is also condition is there. So 1, 2, 3 is right, fourth one is wrong. So recently there is the issue of removal of Supreme Court judge. We should have a detailed information about that. So I will provide in detail just within less time. Number one, the procedure for Supreme Court judge, High Court judge is similar. Number one, the resolution must be introduced in Lok Sabha or maybe Rajya Sabha. Is it clear? If the resolution want to be introduced in Lok Sabha, it must be signed by 100 members. If it is Rajya Sabha, must be signed by 50 members. That is one thing. And second thing, the judges should be given the advance notice also. And one more thing, the speaker of Lok Sabha or chairman of Rajya Sabha. See, if you introduce in Lok Sabha, the speaker has the power. If you introduce in Rajya Sabha, the chairman has the power. And the speaker of Lok Sabha, the speaker of Rajya Sabha has the power to accept the resolution or has the power to reject the resolution. Because whenever if the resolution introduced in Lok Sabha, Rajya Sabha, okay, the speaker by seeing that notification, by seeing that letter, they can accept, reject. Is it clear? That is also remember. For example, if it is introduced in Lok Sabha, for example, it should be signed by how many members? 100 members. immediately the Lok Sabha Speaker is going to appoint a committee, remember that, for inquiry. Because there are some allegations on Supreme Court judge or High Court judge, first we should go for inquiry whether it is a just to, it is a just what packet is the criticism or really committed a crime, we don't know. So we should go for an inquiry of committee. In this committee, the Chief Justice of Supreme Court will be there, or a Supreme Court judge will be there, and also CJF High Court will be there, and also some other members also there. So, but Chief Justice of Supreme Court or Supreme Court judge, Chief Justice of High Court will be there. Is it clear? And the committee will go for inquiry. If the committee says that he is guilty, that means he committed a crime, then they are going for resolution process. If the committee says that not guilty, that means he was not committed any crime, the resolution is going to be stopped. The process is going to be stopped. Okay? So, కమిటీ అనేది అతను తప్పు చేశాడని చెప్పండి అనుకోండి, తప్పు చేశాడని చెప్తే ఏమవుతుంది, ఫర్దర్గా ప్రాసెస్కి వెళ్తారు. తప్పు చేయాలని చెప్తే ప్రాసెస్ అక్కడితో ఆపేస్తారు. ఈజ్ ఇట్ క్లియర్? సో ఇఫ్ ఇట్ ఈస్ ఇన్ లోక్ సభ, ఇట్ షుడ్ బి సైన్ బై 100 members. They are going to committee, appoint a committee, 3 members will be there. They are going to inquiry. If they prove guilty, they will go for next process. Not proved guilty, and no process at all. Suppose if the committee says that the judge committed some kind of wrong things, the committee says that the judge committed some wrong things, corruption or whatever may be, what is the next process? They'll go for resolution. They'll go for resolution. Okay, if it is Lok Sabha, what is the resolution? 2/3 members of present and voting. 2/3 members of present and voting. In Lok Sabha, total members are, for example, we have 542. Okay, 543 total members. 543 total members. Okay. Then what? On that day, 400 members are attend. On that day, 400 members attend. So it is not about the total strength of the Lok Sabha. It is about presenting and voting. On that day, 400 members present and they voted. That means 2/3 of 400. 2/3 of 400. That's it. So 2/3 of 400, the majority. Plus one more thing. Not less than 50% of total strength of the house. That means, what is the total strength of Lok Sabha? 543, for example. 543 is the strength. Then 50% means what? What is the 50% in 543? So 250, 270, 272. That means it should get the majority of 272. So 2/3 of 400 and 272. Suppose if you go to Rajya Sabha, same process. 2/3 of presenting and voting. You know what is the total strength of Lok Sabha, Rajya Sabha? 245. On that, for example, 200 members are present. Okay, 2/3 of 200. And also one more thing, not less than 50% of total strength of the house. That means what is the total strength of Rajya Sabha? 243. So what is 50% of Rajya Sabha? Exactly. So 122. 120 is more than 50%. So this is the process actually. Okay, right. So till now, no Supreme Court judge, High Court judges were removed. Of course, previously, many number of times the resolution was introduced. Sometimes speaker rejected. Sometimes resolution is passed. Sometimes they proved guilty. Sometimes they given resignation. So many things were happening in previous. But till now, no Supreme Court judge, High Court judge was impeached, removed by this Parliament. So Supreme Court judges, High Court judges are removed by whom? Parliament only. Removed by Parliament through a resolution. So what is the procedure? And if it is introduced in Lok Sabha, 100 members should be signed. If it is Rajya Sabha, 50 members should be signed. The Speaker Chairman can accept or reject that resolution. And if it is accepted, the condition should be 2/3 of presenting and voting, and plus not less than 50% of total strength of the house. Is it clear? So this is what happens. Yes, recently Yashwant Verma, Supreme Court judge, the issue is going on. That's why it is required. Because recently, most of the questions are related to polity questions are, first of all, you should give importance to current affairs. So whatever recent issues are going on in polity, you should give first preference. Next, which of the following article deals with acting judges of Supreme Court? Acting judges of Supreme Court. Acting judges of Supreme Court. It looks like simple question, but you have to give the proper answer. Acting judges of Supreme Court. Okay, here did not mention about whether it is Chief Justice or normal judges. So Article 126, 127, 128, 129. Okay, Article 124 deals with what? Appointment of Supreme Court judges. You know that? Appointment of Supreme Court judges, Article 124. Supreme Court judges are appointed by President of India after consultation of collegium. Everybody knows that. Article 125, the salaries of Supreme Court judge. 125, salaries of Supreme Court judge. Yes, right. Okay. So Article 126 deals with appointment of acting Chief Justice of India. Acting Chief Justice of India means, for example, usually Chief Justice of India retires after completion of 65 years. So before completion of 65 years, if the Chief Justice of India suddenly retires or suddenly passes away, someone has to act as a Chief Justice of India. So Article 126 talks about acting Chief Justice of India. Yes, that is the right answer. Yes. Okay. Article 127, appointment of ad hoc judges. Ad hoc judges nothing but called temporary judges. So if the Supreme Court quorum is not enough, if the number of judges are not enough at that point of time, they can appoint some judges as ad hoc judges, temporary judges. Yes. Okay. Next, this is about the retired judges. Retired Supreme Court judges also can appoint as a temporary judges. Retired Supreme Court judges also can be appointed as a judges for temporary period. So these are three articles talking about acting or temporary judges. This is called acting Chief Justice of India. This is ad hoc judges. This is called retired Supreme Court judges can be appointed as a Supreme Court judges. Is it clear? Okay. Article 129, it deals with the court of record. It is not related actually. It is a court of record. What do you mean by court of record? So recording Supreme Court judgments or proceedings which should be followed by the high courts and other courts. That is called court of record. Next, which of the following article deals with the review of judgments of orders of Supreme Court? Usually Supreme Court regularly gives a judgment, right? Sometimes Supreme Court, it can review its own judgments also. So Article 131, 132, 133, 137. What is the right answer? Yes, Arun Kumar right. Yes, D. Okay. 137. Good. It's a simple question actually, but recently in the news only. That's why I framed this question. Okay. So usually I'll start with Article 130. Article 130 deals with the seat of Supreme Court. Seat of Supreme Court means where the Supreme Court is physically located. That is called seat of Supreme Court. It is in Delhi only. And seat of High Court also. Every High Court is located in usual state capacity. That's the seat of High Court, seat of Supreme Court. And what about Article 131, 132, 133 and 134? So these articles actually, 131 to 134 actually article deals with the jurisdiction of Supreme Court. For example, Article 131, it talks about original jurisdiction of Supreme Court. What do you mean by that? Original jurisdiction means, so certain cases can be deal directly with the Supreme Court only with the Supreme Court only. Suppose if there is a issue between states, if there is a issue between two states or two or more states, or if there is a issue between state and center. Suppose there is a issue between Karnataka versus Government of India. Can a Karnataka High Court deal with case? No, because it is an issue between state and central government only. So if there is an issue between center and state, if there is an issue between state and state like that, those cases you can hear in Supreme Court only. That is called original jurisdiction. Even if your fundamental rights are violated, you can directly go to Supreme Court. That is called original jurisdiction. And Article 122, 123 talks about appellate jurisdiction. Appellate jurisdiction means what? Suppose High Court is given judgment, you can appeal in the Supreme Court. That is called appellate jurisdiction. So Article 132, it talks about the constitutional matters. Article 133 talks about the civil matters. So these two are related to appellate jurisdiction. Okay now. I mean Article 134 also same thing. And Article 137, nothing but called review of judgments of Supreme Court. So Supreme Court can review its own judgment, that is called Article 137. Yes, Article 137, correct. And other important articles are there. Article 138 is also there. Article 138, enlargement of Supreme Court powers, that is Article 138. And Article 142, Article 143, what is the specialty? Can anyone tell me in the comments box? Article 142, Article 143. Recently in the news, there is a chance to ask the question also. Article 130, Article 142, Article 143. Okay. Article 142, Supreme Court used recently the Tamil Nadu versus Governor issue. Tamil Nadu versus Governor issue. So Article 142 issued by Supreme Court. Article 142 usually Supreme Court use as extraordinary power. Article 142 is the Supreme Court nothing but extraordinary power in certain cases. If the Supreme Court feels that if the Supreme Court is going to interfere, the complete justice will be happen. If the Supreme Court interferes in the matter, complete justice will happen, and Supreme Court will issue order to anybody in the India, including President also. So recently, the Supreme Court by using Article 142, and issued certain guidelines to the President of India and Governor regarding what? Acceptance of bills. You know that when the Tamil Nadu Assembly passed bills to State Governor, and the State Governor delayed for so many months and so many years also, then the Tamil Nadu government approached the Supreme Court. My dear Supreme Court, the State Governor is not accepting the bills, is delaying the bills, then what we can do? If the Governor is keep on pending the bills, how the state can progress? Then certain bills also, passed by Governor to President also. So then Supreme Court given a judgment that it put some deadlines for Governor and President of India. So my dear President of India, my dear Governor, whenever the State Assembly pass the bills, and you have to accept some days. Some bills are given 1 month, some bills are given 3 months also. I am not going to in detail, but you know that. That is called Article 142. So Article 143, the President of India can ask advice Supreme Court. And after this judgment only, our Honorable President of India, Draupadi Murmu ji, and asked Supreme Court about all these things. So Article 140 nothing but called the President of India can seek advice from Supreme Court. That is called Article 143. Yes, Supreme Court can ask the advice. Yes, that is the right answer only. Article 143. Article 143. Okay. And Article 147 also important, nothing but called interpretation of the Constitution by Supreme Court. Interpretation of the Constitution by Supreme Court. So here I tried to discuss all the articles related to Supreme Court. I just tried. Please go, because recently from the 1 year, many articles related to Supreme Court are in the news. So please go through this Article 124, Article 124, Article 137, Article 138, Article 140, Article 142, Article 143, Article 147, all are important regarding Supreme Court. Next, which of the following not worked as a Deputy Prime Minister? Which of the following not worked as a Deputy Prime Minister? Okay, L.K. Advani, Jagat Jeevan Rao, Lal Bahadur Shastri, Devi Lal. Okay, Rakesh, I will check it. Okay, so what is the right answer? So Lal Bahadur Shastri. So L.K. Advani, just a minute. Answer is Lal Bahadur Shastri. So L.K. Advani, Jagat Jeevan Rao, Devi Lal, Sardar Vallabhbhai Patel, Morarji Desai. So these people worked as a Deputy Prime Minister. L.K. Advani, Babu Jagat Jeevan Rao, Devi Lal, Sardar Vallabhbhai Patel and Morarji Desai. So worked as a Deputy Prime Minister. As you know that we have an article called Article 74 and also Article 75. Article 74 talks about there shall be Council of Ministers headed by Prime Minister. There shall be Council of Ministers headed by Prime Minister to advise President of India on administrative matters. That is called Article 74. Article 75 talks about the Prime Minister, Council of Ministers are appointed by President of India. The Prime Minister, Council of Ministers are give resignation to President of India. Prime Minister, Council of Ministers removed by President of India. So these things are mentioned in Article 75. And Council of Ministers are collectively responsible to Lok Sabha. Collectively responsible to Lok Sabha. A person can be worked as a minister for maximum 6 months without being member of Lok Sabha and Rajya Sabha. So they are all mentioned in Article 75. Sir, why are you explaining all these things? Because in the Constitution, the Prime Minister post is mentioned. But in the Constitution, Deputy Prime Minister is not mentioned. That means the Deputy Prime Minister post is not a constitutional post. Even the Deputy Chief Minister post also not a constitutional post. And as a conventional, we created it, but not mentioned in the Constitution. Okay, and why I asked this question? Because in 2024, LK Advani was honored with the Bharat Ratna Award. LK Advani honored with the Bharat Ratna Award. So that's why there is a chance to ask a question about this Deputy Prime Minister. Until now, Bharat Ratna Award started in 1954. It was given to 3 people, Sri Rajagopalachari, C.V. Raman and Sarvapalli Radhakrishna. And last year in 2024 given to 5 people. Till now, how many people got Bharat Ratna Award? 53 people got Bharat Ratna Award. Okay. You know the Lal Bahadur Shastri importance because he was died in Tashkent. He was the second Prime Minister of India. Of course, Gujarat was acting only. Lal Bahadur Shastri was died in Tashkent only. Next question. Which of the following article deals with the election of Vice President? So recently, Vice President was given resignation. Now, election of Vice President is going to be happen. Even for the next year, for next 1 year, there is always chance to ask a question regarding the Vice President of India. So, which article deals with the election of Vice President? 63, 64, 65, 66. Yes, the article is 66. Article is 66. So, Article 63 actually talk about the office of Vice President of India. That means there shall be Vice President of India. Article 64 talks about the Vice President of India, nothing but called ex officio chairman of the Rajya Sabha. Let's see articles about the person. So Article 66, there shall be Vice President of India. 63, there shall be Vice President of India. 64, Vice President is the ex officio chairman of Council of States. The Council of States nothing but called Rajya Sabha. That means whoever is Vice President of India, he will work as a Rajya Sabha chairman only. Is it clear? As you know that the Vice President of India gets a salary as a Rajya Sabha chairman, not as a Vice President. Next, Article 65. The Vice President to act as a President discharge his function during the casual vacancies in the office during the absence of Vice President. So one of the main duty, the Vice President is having 2 duties. Number 1, he will work as a Rajya Sabha chairman. Everybody knows that. And second one is called he will act as a President of India. He will act as a President of India. So when the President office is vacant, due to resignation, due to death, or impeachment, in that cases, the Vice President will act as a President for the maximum of 6 months only. Who was the first Vice President who acted as a President? That is called V.V. Giri. V.V. Giri was the first Vice President of India who worked as the President of India when the Zakir Hussain was passed away. I mean, I'm talking about the death. Okay, right. So next, Article 66 talk about the election of Vice President, and 67 term of the Vice President. The Vice President term is, that 5 years. The term of the Vice President is 5 years. Okay, oath affirmation and discharge President functions in other contingencies matter. Power of President to cut President, that is not matter. Next question. Which of the following not participate in Vice President election? The question is, which among the following not participate in Vice President election? Which of the following not participate in Vice President election? So elected members of Lok Sabha, elected members of Rajya Sabha, nominated members of Lok Sabha, nominated members of Rajya Sabha. Just think, intentionally I framed this question just in order to give a confusion to you. Who will not participate in the elections of vice president? I didn't ask the question which among the following participated, which of the following not participated. Which among the following not participate in the election of vice president? Okay, right. So elected members of Lok Sabha, elected members of Rajya Sabha, nominated members of Lok Sabha, nominated members of Rajya Sabha. Okay. Actually, do we have a system called nominated members of Lok Sabha? Do you have any system? Earlier in Lok Sabha, if 545 members are there, for example, 545 members are there, 543 elected and 2 are Anglo-Indian community. I am talking about the Anglo-Indian community. Earlier there was a system that the President of India used to nominate 2 Anglo-Indian community to Lok Sabha. So that is abandoned, not following it. So today we have only elected members of Lok Sabha. We don't have any nominated members of Lok Sabha. Is it clear? Yes. Okay, I am going to explain, don't worry, about the procedure of the vice president election. I am going to discuss. Next, find out the false statement about vice president of India. Find out the false statement about vice president of India. He is ex officio chairman of Rajya Sabha, removed by resolution by Rajya Sabha only, submit resignation to president, salary from Consultant Fund of India. Because vice president in the news, you should know about him in detail. So find out the false statement about vice president of India. Yes, he is ex officio chairman of India, just now we discussed. Whoever elected as vice president of India, his main duty to work as a Rajya Sabha chairman. Next, submit resignation to president. Yes, president submit resignation to vice president submit resignation to president. Okay, salary from Consultant of India is absolutely right answer. Yes, yes, this is the wrong answer, because usually the removal of vice president of India resolution first should be introduced only in Rajya Sabha. Resolution must be only introduced in Rajya Sabha. That too, 14 days advance notice should be given. 14 days advance notice should be given and to the vice president of India. So it should be introduced only in Rajya Sabha only. And vice president also can express his views in Rajya Sabha directly or can be indirectly. Okay, and vice president usually removed on the grounds of violation of constitution. Of course, in the constitution, the ground for the removal of vice president was not mentioned. Usually, he is removed on the grounds of violation of constitution. So after passed by Rajya Sabha, it can be sent to Lok Sabha also. It can be sent to Lok Sabha also. That means the removal resolution of vice president of India, it should be passed by both of the houses. First Rajya Sabha, then agreed by Lok Sabha. Agreed by Lok Sabha. But here I mentioned as a only. Mentioned as a only. Okay. But there is a lot of differences between president removal, vice president removal. There is a lot of difference. So regarding president of India, regarding vice president of India, right? Regarding president of India, resolution can be introduced in Lok Sabha or Rajya Sabha. But regarding vice president of India, only Rajya Sabha. President of India can be removed violation of constitution. That is clearly mentioned. But here clearly not mentioned. But of course, he is also removed by the vice president of India. President of India can be removed by a majority, 2/3 of presenting and voting. 2/3 of presenting and voting, no. So 2/3 of total strength of the house. That is different. Here, that is a majority effective, majority in vice president of India. That is, majority is also different. No president is removed, no vice president is also removed. Okay, a lot of differences are there. President removal process is called impeachment. Next, which of the following vice president not worked as a president? So we have so many vice presidents are there, right? Out of some vice president, some worked as a president, some not worked as a president. The question is, which among the following vice president not worked as a president? So V.V. Giri, K.R. Narayan, Shankar Dayal Sharma, R. Venkatraman, B.D. Jatti. So multiple options given. I given 5 options for your convenience. Okay, the answer is BD Jatti. The answer is BD Jatti. Okay, let's see. First of all, you know that Radhakrishna. Sarvepalli Radhakrishna worked as a vice president for 2 times. He worked as a vice president for 2 times. Then later, he was become president of India. Sarvepalli Radhakrishna. Zakir Hussain also worked as a vice president and later worked as a president also. So Sarvepalli Radhakrishna, Zakir Hussain both worked as a vice president, later president also. But Zakir Hussain is the first president who died in office. First president who died in office. Okay, next. And V.V. Giri, who is working as a vice president, all of a sudden acted as a president. So first vice president who acted as a president is V.V. Giri. But later in the elections, V.V. Giri won in the elections and he was became the president also. So Sarvepalli Radhakrishna, Zakir Hussain, V.V. Giri. 3 people worked as a vice president and also next president. Next to Swarup Pathak, no, not worked as a president. And BD Jatti worked as a vice president but not as a president. And Muhammad Hidayatullah. Muhammad Hidayatullah is the only one person who worked as a vice president, acted as a president and worked as a chief justice of India. When the Zakir Hussain was died and V.V. Giri was acted as a president, he also given resignation. At a time, both president and vice president are vacant. At that point of time, Muhammad Hidayatullah was the chief justice of India. So he is the only one chief justice of India who acted as a president of India. Next, R. Venkatraman. R. Venkatraman also became the president. Shankar Dayal Sharma also became the president. Okay, K.R. Narayana also became the president. So Sarvepalli Radhakrishna, Zakir Hussain, V.V. Giri, R. Venkatraman, Shankar Dayal Sharma, K.R. Narayan. So these people worked as a president. But after K.R. Narayan, whoever the persons are there, and they worked as only vice president, but not as a president. You have to remember this one. After K.R. Narayana, Krishna Kant, Bairan Singh Shekhawat, Hamid Ansari, Venkaya Naidu, and Jagdeep Dhankar, these people only worked as a president, worked as a vice president, but not as a president. Is it clear? Okay. Next question. Which of the following vice president worked for 2 times? You know, Sarvepalli Radhakrishna 2 times. Then later who? The next, Hamid Ansari, 2007 to 2017. Hamid Ansari also 2 times. Hamid Ansari also 2 times. The next, Jagdeep Dhankar. Of course, he is also worked as a 2nd time, but he was given resignation. Of course, time is there, but he was given the resignation. Okay. Next, Krishna Kant. Krishna Kant actually died in the office. Krishna Kant died in the office. And which vice president worked for shortest time is called V.V. Giri. V.V. Giri was one person who worked for shortest time. Which vice president worked as for shortest time is called V.V. Giri. Okay, all these are important things for your examination. Go through this one. Okay. Next, which of the following statement is false about Zonal Council? So recently Zonal Council is also in the news. Which of the following is a false statement about Zonal Council? So mentioned in the State Reorganization Act 1956, bringing out national integration is objective. There are totally 5 zonal councils. Chief Minister is the chairman of each zonal this council. So zonal council like North Council, like West Council, like South Council, like East Council, like Central Council, like 5 zonal councils are there. Okay. So which of the following statement is false? So it is said that mentioned in the State Reorganization Act, and it mentioned about bringing out national integration. There are 5 zonal councils are there. Chief Minister is the chairman of each of these zonal council. So what is the false statement? So what is the false statement? This is the false statement, because not the Chief Minister, Union Home Minister. So Union Home Minister is the chairman of the zonal council. Very simple. You know, actually it is the idea of the Nehru, our first Prime Minister of India, Pandit Jalal Nehru ji. It is his idea only, because in 1955-56, when the debate is going on regarding State Reorganization Act, the Nehru ji thought that there should be councils in India because we should bring all the states together to discuss the issues. So we should divide entire India into zonal councils only. So South Chief Ministers will come together to discuss their problems. North Chief Ministers will come together to discuss their problems. So like that, Nehruji was the put forward this idea, and it is actually mentioned in the State Reorganization Act. Yes, the zonal councils is the one which mentioned in the State Reorganization Act. Of course, to bring out the national integration, to put all the states at one place. There are totally 5 zonal councils are there. It is absolutely right. And the Chief Minister is the chairman. No, it is the Union Home Minister is the chairman. Union Home Minister is the chairman. Let's see. So first Northern Council, Haryana, Himachal Pradesh, Jammu and Kashmir, Punjab, Rajasthan, Delhi and Chandigarh are in Northern. Next Central, Chhattisgarh, Uttarakhand, Uttar Pradesh, Madhya Pradesh. And next one Southern, Eastern, Bihar, Jharkhand, Orissa, Sikkim and West Bengal. Western, Goa, Gujarat, Maharashtra, Daman and Diu, Dadra and Haveli. Okay. The next Southern, AP, Karnataka, Kerala, Tamil Nadu, Puducherry. Sir, what about Northeastern states, sir? Yes. For Northeastern states, there is a special council is there. Northeastern Special Council is there, which was set up by an act called Northeastern Council Act 1972. Is it clear? So now there is a chance to ask a question about the zonal councils. Okay, the zonal council chairman is Union Home Minister. Totally 5 zonal councils are there. The main intention is for national integration. Is it clear? Let's see. Now it is also in the news. Which of the following is not a classical language? Which of the following is not a classical language? So I want to test your honest knowledge. Because when multiple options are given, sometimes even though you don't know the right answer, you are going to guess it. But here I want to test the true knowledge of the students. That means if anyone give the correct answer, definitely can say that you know the right answer. That means you are not guessing, you are not bluffing. So which of the following is not a classical language? Prakrit, Pali, Bengali, Marathi. Anyone? C, Bengali. The Venkat is saying that C. So Akila also C. Let's see. Okay, the right answer is all are classical languages only. All are classical languages only. Okay, you know the classical language which has the history of almost 1000 years, 1500 years history is there. That is what called classical language. But recently, Government of India, without looking into all these conditions, it was given classical language status to some of the languages. So that is called Prakrit, Pali, Bengali and Marathi and also Assami. These languages were given classical status by Government of India recently. Earlier, we have classical languages called Tamil, Telugu, the Malayalam, okay, the Kannada, the Oriya, of course I am calling as a Oriya, because Sanskrit is there. So these are languages called as a classical languages. So last year government given classical language status to these also, Prakrit, Pali, Bengali, Marathi and also Assami also. Am I right? Yes, you can comment also. 22 are official languages, not classical languages. 22 official languages. We have a 8th schedule. In 8th schedule, 22 official languages are mentioned. Official languages are mentioned in the Constitution. These are classical languages. Next, which are the following not true about interstate council? Interstate council. See, 22 we have classical languages. Official language mentioned in the 8th schedule of the Constitution, totally 22. So classical languages are announced by Government of India. Okay, and in the original Constitution, in the 8th schedule, initially how many official languages are there? 14 official languages are there. That means January 26, 1950, when the Constitution came into effect, in the 8th schedule, 14 official languages are there. Then later, by 21st Amendment, the Sindhi language was added. By 71st Amendment, the Konkani, Nepali and Manipuri language was added. By 92nd amendment to the Bodo, the Dongri, the Santali, the Maithili, so these languages were added. Okay, these languages were added. 21st amendment Sindh, 71st amendment Konkari, Manipuri, Nepali, and Bodo, Dongri, Santali, Maithili was 92nd amendment. Okay, right. Next, which are the following not true about interstate council? It is also in the news. Already last year in the group 1 examination, the question was already asked. So, which of the following statement is not true? Not true means false. You have to identify the false statement. So, it is a constitutional body under Article 263. Is it correct? Appointed by President of India for every 5 years. And members are Chief Ministers of all states, Union Territory with a legislature, and 6 Union Ministers nominated by Prime Minister and recommended by Sarkariya Commission. Which statement is false about interstate council? Is it really constitutional body? Yes. Yes, it is a constitutional body under Article 263, appointed by President of India, but not exactly for 5 years. That is wrong. You know, which commission was appointed by President of India for every 5 years? Finance Commission. Finance Commission appointed by President of India for every 5 years. That is wrong statement. Yet Chief Ministers of all states and also Chief Ministers of all states and also the Chief Ministers of UT with the legislature and also Administrator of UTs and also 6 Union Ministers nominated by Prime Minister. Yes, it is also recommended by Sarkariya Commission. Also recommended by Sarkariya Commission. So, interstate council appointed by President of India under Article 263, who are members, all Chief Ministers, Administrators of UP, Union Territory, or Chief Ministers of UT if the Assembly is there, 6 Union Ministers nominated by President or Prime Minister of India, and also one of the recommendation given by Sarkariya Commission also. Next, which are the following not a statutory body? Statutory body, that means legal body. So, question is, which of the following is a not a legal body? Which of the following is a not a legal body? So, Criminal Investigation Department, nothing but called CID, Central Bureau of Investigation, CBI, and Lokpal, and also Central Vigilance Commission, CVC. So, which of the following is a not a statutory body? This is I am leaving to you, and I am expecting someone has to give the answer in the comment section after live is over. I am leaving up to you, but I am going to explain. You know that the CID is nothing but called state level. CID is nothing but called state level. CBI is nothing but called central level. It is the central level. Both are going to deal with so many cases like maybe criminal, maybe economic offense, maybe cyber crime, anything can be deal with the CID as well as the CBI. It is the state level, it is the central level. Even sometimes the state government also can give certain cases to CBI also. Everybody knows that the CBI and CID. It is a state level body established by state government only. CBI was established 1946 as per there is a provision in the Delhi Special Police Establishment Act. The Delhi Special Police Establishment Act. Under this act we have a provision of the Central Bureau of Investigation. Okay, and Lokpal, you know, because of a movement called India Against Corruption by Anna Hazare, all these people, the Lokpal was established as per act only. The Lokpal is going to deal with corruption cases, including the Prime Minister also. The Prime Minister, Ministers, MPs, all these people, corruption cases can be dealt with the Lokpal. And the Central Vigilance Commission, it is also deals with the corruption. Indian IAS officers or Group A officers, those kind of officers, it is try to prevent the corruption, Central Vigilance Commission. So, I am giving option to you, which one is right one, or any controversy is there, you can give the controversy also. I am leaving up to you. So, tribunals are added by which amendment? Tribunals are added by which amendment? 36th amendment, 42nd amendment, 44th amendment and 48th amendment. What is the right answer? 42nd amendment. You know that? 42nd amendment is also known as mini constitution. It is also known as mini constitution. So, not only this tribunals, many things are added by 42nd amendment. Even the fundamental duties and also tribunal, fundamental duties, tribunal. Okay, many things are added by 42nd amendment. Can one tell me what are other things are added by this 42nd amendment, but is also known as mini constitution? Later 44th amendment done by Morarji Desai, which changed so many things which are done by 42nd amendment. Yes, mini constitution. Next, incorrectly matched. Which one is incorrectly matched? So, first amendment related to reservation, fifth amendment related to formation of states, seventh amendment related to state reorganization, 11th amendment related to the election procedure of the president. It is not about the article, amendment. Through amendment, they did something changes. So, through first amendment, something related to reservation. See, through one amendment, they are going to change many articles. You know that through one amendment, they can changes in many articles. So, first amendment has many provisions. One of the provisions is reservation. Fifth amendment is having many provisions. One of the provisions is formation of states. Like that, given left side amendments were given, right side the data was given. So, one is incorrectly matched. Which one is incorrectly matched? Yes, preamble also. Through 42nd amendment, preamble was amended through 42nd amendment. You know, the words were added. You know, socialism, socialism, integrity. Yes, secular socialism, integrity was added through 42nd amendment into preamble. That is the right answer. What is the wrong answer here? Okay, so come to this question. Yes, the first amendment is related to reservation also, and first amendment related to actual land reforms also. First amendment related to land reform, Jamindar statement, Jamindar also. It was added the 9th schedule also. It was added the 9th schedule. The first constitutional amendment added the 9th schedule. First constitutional amendment related to Jamindari Vyavastha, and first constitutional amendment related to reservation, because ST was given reservation, and they amended the Article 15. They amended the Article 15 also ST because of one Supreme Court judgment. So the Champak Durai Rajan case. So Champak Durai Rajan case. In Champak Durai Rajan case, the Supreme Court rejected reservation system in the employment because it is not mentioned in the original constitution. Based on the Supreme Court judgment only, the government of India amended the constitution through first amendment. They added reservation system SC/ST. Okay, and the fifth amendment related to formation of states. You know, as you know that the formation of states bill can be introduced with the prior permission of president. You know that the creation of new state bill can be introduced with the prior permission of president only. The president of India will send the creation of new state bill to the state legislative assembly. Everybody knows that. When the president of India send the creation of new state bill to concerned state assembly, he will put some limit number of days. You know, during Telangana bill also, the president of India sent the AP reorganization bill to AP assembly by giving certain number of days as a time frame. So that was mentioned in the fifth amendment. And seventh amendment related to state organization. You know, State Reorganization Act was passed in 1956. That is called seventh amendment is there. And through this only, the part 7 was removed. You know that. Yes, 11th amendment related to not president, it is related to vice president. Yes, the procedure related to vice president of India was amended by 11th amendment. So recently the vice president election in the news, there is a chance to ask the question. Thus I framed it. Which are the following incorrectly matched? 10th amendment related to Dadra and Haveli. 12th amendment related to Goa, 14th amendment related to Pondicherry, 15th amendment related to Daman and Dayu. So here the answer can be all are incorrect, all are correct, or one is incorrect. I am giving option to you. All are incorrect, all are correct, or one is incorrect. Then what is the right answer? The right answer means the right incorrect answer is yes, Daman and Dayu. Actually, 12th amendment deals with not only Goa but also Daman and Dayu also. So this is the wrong one. So you can remember that the union territories was added into India. The territories which are ruled by Portuguese and French add into India. The 10th amendment added Dadra and Haveli, which is under control of Portuguese. The 12th amendment added Goa and Daman and Dayu. Daman and Dayu. So Daman and Dayu also, which are under control of Portuguese. You know that. So under Portuguese only. You know that Operation Vijay, through Operation Vijay, the Goa has become part of India, and Goa made as a union territory. Dadra and Haveli as a union territory, Goa, Daman and Dayu together union territory by 12th amendment. By 14th amendment, Pondicherry is also, not only become part of India, become a union territory, Pondicherry. It is under control of whom? French only. So these are under control of Portuguese, Pondicherry under control of French. Daman and Dayu is actually it is the wrong answer. Daman and Dayu is the wrong answer. And we can remember as a DGP, 10, 12, 14, DGP. Remember, it's very easy. Later, this Goa and Daman and Dayu made as a separate UT, and Goa was became the 25th state of India by 1987. In 1987, Goa has become the 25th state of India. So Goa was added into India as a union territory. In 1987, it became the state only, full-fledged state only. So this is a repeated question in any examination about the union territories. Now there is a chance to ask the question about the list of union territories. Please go through it. Okay. So which of the following not correctly matched? Which of the following not correctly matched? Article 13, equal pay for equal work. Article 42, living wage and decent standard of life. Article 46, educational economic interests of SC and ST. And Article 48, improve public health. So what is the right answer? I am waiting for your answer. Yes, try. So here can be multiple options can be wrong. Try to find out multiple options also. Venkat said A. Article 36 deals with the state. What is state? Article 36. Now Article 37, Article 38, Article 39. As per Article 37, you know that DPSP, Directive Principal State Policy Laws, are not enforceable by the Supreme Court, because the DPSP can be implemented by government, maybe or may not be. It is not like a fundamental rights. So fundamental rights are justiciable in nature. If fundamental rights are violated, we can go to Supreme Court or High Court. So DPSPs are not justiciable in nature. If they are not implemented by government, we cannot move to court. They are not justiciable. That is also mentioned. So Article 39, yes, equal pay for equal work. That is right answer. Someone say B is also right answer. B. So living wage and decent right. It is right one actually. It is correct, not wrong. Why B is wrong? Because it is not about Article 42. It is actually Article 43. You are right, Venkat. Article 43. Educational economic interest of SC and SC. This is right. This is right. This is wrong. This is right. What about to improve public health? Is it Article 48 or 47 or 48? What is the right one? So this is not 48, this is 47. Repeatedly they are asking question about DPSP articles. My dear students, you have to remember DPSP articles at any cost, whether you are preparing for central examination, state examination. Okay? Right. Identify incorrectly matched pair. So drafting committee, Dr. Bhimrao Ambedkar. Union Power Committee, Jawaharlal Nehru. Provincial Constitution Committee, Vallabhbhai Patel. And Fundamental Rights Subcommittee, S.C. Mukherjee. Very easy question. Yes. Very, very easy question. Anyone can answer. Yes, Article 44 Uniform Civil Code, Article 40 about organization of Panchayat. You ought to be remember. So Fundamental Rights Subcommittee not by H.C. Mukherjee. It is by J.B. Kripalani. J.B. Kripalani. Fundamental Rights Subcommittee. Is it clear? It is a subcommittee. Fundamental Rights Subcommittee. Fundamental Rights Subcommittee, S.C. Mukherjee, not J.B. Kripalani. What about this one? Because Constituent Assembly committees are repeated questions. Please go through this. Identify the correctly matched. Rules of Procedure Committee, Babur Andhra Prasad. Committee for the Functions of Constituent Assembly, K. Munshi. House Committee, Pattabi Sitaramaya. Language Committee, Moturi Satyanarayana. So which one of the incorrectly matched? Which one of the incorrectly matched about the committees? This is one of the repeated question in any exam. Which one is incorrectly matched? You can simply say this one is incorrectly matched, right? Functions of the Constituent Assembly by G.V. Mavalankar. G.V. Mavalankar. You know, because G.V. Mavalankar also worked as the first speaker of Lok Sabha is G.V. Mavalankar. You know, Constituent Assembly, that Rajyanga Parishad have two functions. Okay. What are the two functions? Number one, to prepare constitution. To prepare constitution is one function, and it is like a parliament. It is like a parliament. So when the Constituent Assembly preparing constitution, discussing constitution, Babu Rajendra Prasad as like a chairman, as president of the Constituent Assembly. But the same Constituent Assembly behave like a parliament or passing the laws like a parliament, and G.V. Mavalankar was the chairman or president. G.V. Mavalankar. So he is the first Lok Sabha speaker, you know that G.V. Mavalankar. That is what is called, this is also wrong one, K. Munshi is wrong one. Any other option you can explain? Is it correct? House of Committee Pattabi Sitaramaya correct? Language Committee Moturi Satyanarayana correct? I am expecting an answer from you. Okay, this is said you are wrong. Moturi Satyanarayana wrong. Then there should be right answer, right? BG Care. BG Care. Okay. And there is one more thing you should understand, that the same Constituent Assembly appointed first linguistic commission. First linguistic commission. What is the first linguistic commission appointed by the Constituent Assembly? Babu Rajendra Prasad, the President of India. The first linguistic commission, S.K. Dhar. S.K. Dhar is the first linguistic commission. The people from Madras, the Telugu speaking people from Madras, who demand separate Telugu state, and based on the demand only, the Constituent Assembly, the Babu Rajendra Prasad, appointed the first linguistic commission, that is called S.K. Dhar Commission. Later they appointed one more commission called JVP Committee, Jawaharlal Nehru, Sardar Vallabhbhai Patel, Pattabi Sitaramaya. Later in 1953, they appointed State Reorganization Commission, headed by Fazal Ali. So any examination, these three committees are important. S.K. Dhar Commission and JVP Committee, Fazal Ali Committee. Next, which among the following not a Center-State Relation Commission? There are four committees are given. It is also repeated question. Center-State Relation Commission. So I am waiting for your options. Are you getting my comments? Yes, first state to form on the base of linguistic is Andhra Pradesh. Before independence, Orissa. After independence is Andhra Pradesh. Yes. Okay, here, yes, okay. Sarkaria Commission, Poonch Commission, Raj Manar Commission. Okay, the Manar Commission was appointed in 1969. Actually, the answer is first I need to tell the answer Veerappa Moily. Veerappa Moily is nothing but called Administrative Reforms Commission. Administrative Reforms Commission. Second Administrative Reforms Commission was appointed by Government of India, that is called Veerappa Moily. Before that we have a first Administrative Reforms Commission by Morarji Desai. So Veerappa Moily is head of the second Administrative Reforms Commission. And Raj Manar is the Central State Relations, Poonch also Central State Relations, Sarkaria Commission also Central State Relations. Yes. So 1983, 2007. Sometimes there is a chance to ask the question in state level examination, arrange the following committees in chronological order. For that purpose, you should know the years also. You should know the years also. Yes, Veerappa Moily. Next, which article deals with assent of the bills by governor? Which article deals with assent of the governors? You know, whenever a state legislative assembly, when the state legislative assembly send a bill to governor of the state, so which article deals with assent of the governor? Because recently in the news, everyone knows that. Very simple, straightforward question. Very simple, straightforward question. Yes, the answer is 200. The answer is 200. Okay. So, under which of the following situation a member can be disqualified under 10th schedule? So, recently Supreme Court given a judgment. It said that the Telangana Assembly Speaker to decide disqualification of MLAs, disqualification of MLAs within 3 months. Within 3 months. So, Supreme Court put a deadline to the Telangana Assembly Speaker to take a decision on disqualification of MLAs. So, based on that situation, in upcoming examination, there is always chance to ask the question, maybe easy question, maybe difficult question, including civil service also, about the anti-defection law. So, my dear students, please go through anti-defection law thoroughly in detail. Any question can be asked, maybe very easy question or maybe difficult question. So, the question is, in which of the following situation a member can be disqualified under 10th schedule? Here in this question there is a twist is there. There is a twist. I want to test your real knowledge, whether you are going through just randomly giving answer or throwing stones. I want to know. There is a twist in this question. Okay, let me tell you, all are correct. All are correct. Okay, because when MP or MLA can be disqualified under the 10th schedule, you know that through 52nd amendment, during Rajiv Gandhi, they added a new schedule called the 10th schedule, which is called as a anti-defection law. The anti-defection law talks about disqualification of MPs or MLAs under certain conditions. Okay? Yes, under certain conditions. Number 1, elected from party and joined into other party. Elected from one party, joined to other party. So, you elected from BJP, joined into Congress, you will be disqualified. That's it. No more arguments. If independent member joined into any party, but here some condition is there. One condition is there. Okay, independent party joined any party is disqualified. That's it. No more questions. If he voluntarily resigned for his party, suppose I am elected from Congress party, I wrote a letter to Congress party, I am resigning. That's it. You will be disqualified. And if you go against whip or any order issued by party, suppose in the Parliament Assembly the bill procedure is going on. The party issued an order called whip. The party is issued a whip. The party said that you should attend the assembly session, you should vote against the bill, but you voted to support the bill. You voted and through support, you supported the bill, you will be disqualified. So, these 4 all statements are correct. 4 statements are correct. 4 statements are correct. And these 4 things, 4 statements, a person can be disqualified. Even one party merged into other political party, if one party, 2/3 members of one party joined into other party, yes, no problem at all. No need of disqualification. if 2/3 of one 2/3 members of one political party and joined into other political party, simply merging of party happens, no disqualification. No disqualification, I am telling that. Okay, so please go through that. Union territories was introduced by which of the following amendment? Please go through this question. Yes, recently I asked you this question. That's why I made again. Okay, what is the problem this one? Why? Even though this 52nd amendment 10 schedule is there, so many people elected from one political party joining into other political party. But in many cases, they are not disqualifying. The biggest problem with this is the speaker. Okay, in this as per 10 schedule, who has to take the decision on disqualification of MLAs or MPs? The Speaker of Lok Sabha for MPs, the Speaker of Assembly for MLAs. So there is no time bound period. There is no time bound period for Speaker. If the complaint is given to Speaker on disqualification of MLAs, in the Constitution, the time frame is not fixed. So that's why the Speaker is not taking a decision. So I am not insulting Speaker, but the truth is very, very important. If the Speaker is not taking any decision on disqualification of MPs or MLAs for 3 years and 4 years and 5 years, then what is the bloody use of this anti-defection law? Then what is the use? If the no speaker is taking any decision, if the no speaker of any state or Lok Sabha speaker are not taking decision on disqualification, if the proper ground is there, proper information is there, proper evidence is there for joining of a political party, the speaker is not taking any decision for 1 year, 2 year, 3 year or 4 years, then what is the use of this anti-defection law? It is a dead, no use at all, no use at all. Let the speaker take the decision, then there is no use at all. For all these are just useless. The speaker is honestly taking decision on this anti-defection law within 3 months or 1 year with proper evidence, it is a good thing, but they are not taking decision. The Supreme Court said that, then what is the use? They keep on pending for 5 years, then what is the use? What is the purpose of this anti-defection law? Okay, I told you about the Union territories, right? I told you about the Union territories. Currently we have 9 Union territories or 8 Union territories. So NCT of Delhi, it is called New Delhi, High Court is there, Assembly is there. Out of all the Union territories, 3 Union territories are having Assembly. Jammu and Kashmir is having Assembly, Delhi having Assembly, Pondicherry is having Assembly. Out of all the Union territories, 2 UTs are having High Court. So Delhi is having High Court and Jammu and Kashmir is also having the High Court also. The present Jammu and Kashmir and Ladakh, you know that? Ladakh. So Jammu and Kashmir and Ladakh, they became Union Territory October 2019. And without assembly, Andaman Nicobar is having not assembly. Chandigarh also is a capital of both states. Dadra and Haveli, Daman and Diu. So they made together as a common UT. They made as a common UT in January 2020. Okay. So UT is the headquarter. Simple question, simple answer. And it shall be the duty of the union to promote the spread of. It is the duty, it shall be the duty of the union to promote the spread of, because there is a language issues going on throughout the nation. Recently, Tamil Nadu, Kamal Hassan, some kind of statements, create a controversy about the language. Okay, what it shall be the duty of the union government to promote the spread of A. Sanskrit, B. Hindi, all classical languages, none of this. I am expecting a right answer from the students. Very simple question. None of this, none of this. I expected this. I expected this. I know that everyone will say that none of this, none of this. Yeah. See, you should understand the question. You should know the Constitution, right? I am not talking about the official language, classical language. No. Here clearly mentioned that it shall be the duty of the union to promote the spread of Hindi. Okay. This question is not about what is the official language of union. No. Yes, there is an article which says that it shall be the duty of the union government to promote Hindi language. There is an article in the Constitution. So, Hindi. This question is not about what is the official language of India, what is the national language of India. That is not the question. In Constitution it is mentioned, it should be the duty of the Union to promote language of spread of Hindi. Yes. Okay, please go through these questions. You know that in the Supreme Court, High Court, what is the language they use? English they are going to use. Article 343 talks about the official language of the Union. Article 344 talks about the Commission Committees of the Parliament of official language. Article 345 official language of the state. Article 346 communication between two states. And Article 348 talks about language to be used in the Supreme Court and High Court and for bills also. In High Court, Supreme Court, what is the language? English is the language, right? And this is important. As per Article 350B, the President of India appoints a special officer for linguistic minorities. This is very, very, very important. Please go through this. Okay, right? The time is over. Of course, still so many current affairs questions are there, but I will continue in the next session.